Next case on the docket will be the first case, Shorter versus State. All right, we welcome Judge Palmer, and we'll proceed with the case.
May it please the Court, my name is Jim Fellman, and I'm with the Tampa law firm of Kynes, Markman, and Fellman, and I'm here this afternoon on behalf of the appellants Terrence and DALTONICA Shorter, and I would like to reserve 3 minutes of my time for rebuttal, please.
Okay.
This case presents questions that are important about the jurisdiction and authority of the Office of the Statewide Prosecutor and the ability of that office to use Florida's RICO statutes to impose cumulative punishment for crimes already prosecuted and for which the defendants have already been punished. The convictions of both defendants should be reversed because the Office of Statewide Prosecution and therefore the trial court had no jurisdiction, because the venue of the case in Orange County was improper, because the evidence as to both defendants was insufficient on the issues of both pattern and enterprise, and because there were a host of prejudicial evidentiary errors, including the admission of testimony by a so-called gang expert, extensive and gruesome testimony regarding an unrelated murder, and the admission of hearsay prior judgments of conviction that arose from no contest pleas.
Start with that last one, if you would, and address the issue about the NOLO pleas.
The law in Florida is clear that a no contest plea is not admissible in a subsequent criminal prosecution. The state attempted to, and run around that by instead introducing into evidence over defense objection the judgments of conviction that resulted from those pleas. That was error because those items are hearsay.
What was the objection that was made at trial?
It was a different objection. It was based on, the objection at trial was that it was a no contest plea. So we're left with fundamental error as to that particular issue. The state doesn't contest that it was error. They make no argument that these documents were properly admissible. They argue only just that it was not preserved and that it's not fundamental and it's not prejudicial.
So what was actually introduced at the trial?
The actual court document that was the judgment of conviction.
Something must have been introduced about it being a NOLO plea, because wasn't there a limiting instruction to the jury about what the significance or insignificance of a NOLO plea would be?
There must have been, Your Honor, and I apologize. I don't remember exactly how that was handled, but the jury was instructed on that. But we don't think that it matters, because under any scenario, the admission of the document would have been error. And when it comes to, because it's hearsay, the state doesn't contend otherwise. And it's clear fundamental error because on that particular predicate incident, the one that is at issue here, the predicate incident 2, that's a predicate incident that alleged that the defendants discharged firearms from within a vehicle. The state called 3 live witnesses who witnessed the events, and all 3 of the witnesses testified that no one discharged any firearms from within a vehicle, that they were all outside of the vehicle, got shot at first, and then some of them fired back. So the only way the state could rebut its own witnesses who unanimously exculpated the defendants was through this document that was wrongfully admitted.
When are judgments allowed to be admitted?
If they are the result of a guilty plea. Then the guilty plea and the guilty plea colloquy.
Where does it say that? The rule says, and I'm looking at 9410, evidence of a plea of guilty, later withdrawn, a plea of nolo contendere is inadmissible. There's a difference between the plea and the subsequent conviction, isn't there?
I think.
And I know the Napoli case says, well, there's no exception like there is in the federal rules for convictions based on nolo contendere pleas, but the rule specifically refers to the plea. And doesn't the rule specifically prohibit discussions concerning the plea, what may have been said during the plea colloquy, rather than the conviction that follows the trial court's finding of a factual basis and the entire colloquy that's necessary in order to get to the conviction in the first place. Isn't that right?
I think that the rule is as Your Honor stated it, but there is then the hearsay problem of the resulting judgment. And I don't think that the state gets to do just an end run around the rule by putting in the document.
How is that an
results from the process.
end run around the rule when the rule specifically relates to the plea rather than to the resulting conviction that follows the plea? The conviction is a judgment that says that he is adjudicated guilty of this crime. And, you know, a conviction can result in a lot of adverse consequences in a lot of different scenarios. It can up the score on a score sheet and dramatically change the sentence. It can be evidence of a violation of probation that can result in a long sentence. It can qualify as a predicate offense for a habitual offender or imposition of all sorts of minimum mandatory sentences, but then it can't be introduced into evidence in a subsequent criminal proceeding. Makes no sense to me, really.
Well, I think that all of the things that Your Honor articulated that they could be used for are all for a judge to decide, and they're all as a matter of operation of law and the application of certain recidivism statutes and things of that nature in sentencing. These were admitted for substantive proof of the truth of what occurred that day.
Now, you said if it had been a judgment pursuant to a guilty plea, it would have been admissible?
You know,
are you saying then it's not hearsay, or that's some recognized exception? How is the judgment different if it's a judgment pursuant to a guilty plea versus pursuant to a no?
I may have misspoken in light of what Judge Soraya just read. I was under the impression that a guilty plea gets admitted substantively in terms of the colloquy, you know, that you can put in that the defendant stood there and raised his hand and said, I admit I'm guilty.
Those are statements
Correct.
that relate to the plea. We're talking about the underlying conviction now.
Yeah, and I think my answer then would be that
There really wouldn't be any difference.
that the court document would still be hearsay.
Well,
in any event, I think the more power...
Is there any other case other than the Napoli case that says, that, well, there's no federal counterpart? The federal rules apparently have an exception for that. Well, we don't have the exception in Florida, therefore it's hearsay.
I don't think so, Your Honor. I certainly would have cited it in my brief if I was aware of it, and I can't think of any right now. I think, however, that this is obviously an issue of interest to the court. The court need not reach this issue in light of the number of other issues that just knock the whole case out of the water, primarily the jurisdiction issue. Okay,
so back to that is one further question. You acknowledged that the only objection that you made was the basis of it being a nolo contendory plea, and you didn't object based on hearsay, but you're saying that, well, nevertheless, it constitutes fundamental error?
That's correct, and I wasn't the trial counsel, but that's my recollection of the record, Your Honor. I think that it's correct that the objection was made on a different point. We think it would be fundamental because it's the only evidence that rebuts the live testimony, and that, at least as to DALTONICA, would be a required predicate in order for there to be two of them. So their whole case against Mr. DALTONICA Shorter hangs on that document alone. The reason there's no jurisdiction is because the statewide prosecutor can prosecute cases only which affect or occur in two different judicial circuits. And here, all of the behavior occurred only in one. The state does not contest otherwise. They have mounted no argument that this case affected or occurred in more than one circuit. They instead raised two.
Well, they didn't they tie it to the source of the drugs that were part of it?
From Orlando.
They make no argument that that satisfied their jurisdiction. I argued in the initial brief that the only connection was that a man who was not alleged to have been a member of the conspiracy testified that Terrence Shorter, at some unspecified time period, told him that he used to get his drugs from Miami. No time period. The state makes no effort to argue that that witness's testimony established that this conduct that was alleged in the indictment actually took place in Miami. They have two arguments that they make. One is that the defendants waived the trial court's lack of jurisdiction. Lack of jurisdiction cannot be waived, nor may jurisdiction be conferred upon a court by the consent of the defendant. The second argument that they make is that it was unpreserved. Well, it's the same essential argument, that it was not, that the objection was not timely made. And the case law is quite clear that lack of jurisdiction may be raised at any time because all of the proceedings are void, including the Brown decision that I note that both Judge Sawaya and Judge Griffin participated in. That is fairly clear cut. The second argument that they make, I think, is simply remarkable, and it is that they need not prove what they allege, that it is sufficient if they allege in the indictment that it occurred in more than one judicial circuit, and that must end the inquiry. And even if they fail to prove what they have alleged, there is nothing that anyone can do about it. They may aggregate to themselves jurisdiction by the mere election to allege that they have it. No case supports that proposition, and there are a number of cases that are directly against that proposition. And I've cited them in the brief, and the state did not cite or discuss any of them. There is no real difficult question on point one. There are a number of cases that say that it is not sufficient to simply allege jurisdiction. This court, when challenged by the defendant, the court must look at whether the facts actually support jurisdiction. Here they do not, and the state makes no argument that they do, nor could they. Moreover, even if there had been jurisdiction, the venue in Orange County was improper.
Was there no testimony about a tie to Orange County as the source of the, didn't somebody testify that that was the source of the drugs?
One of the state's witnesses said that he purchased some of the drugs that he sold to the defendants in Orange County. That person was not alleged to have been a member of the conspiracy or the enterprise. There was no evidence that any member of the enterprise knew that he had purchased the drugs there, that they instructed him to purchase the drugs there, that they wanted him to, and there was no testimony of anything ever being sold there. If it were sufficient to establish venue that the drugs were purchased by one of the people in the chain of supply who is not a member of the conspiracy, that the drugs ever passed through that jurisdiction, first I would say there is no case law that would support that novel proposition, and secondly, the implications of it are quite far-reaching. It would announce essentially a new rule of venue in Florida, that in any drug case, a defendant may be prosecuted in any jurisdiction in which any of the drugs ever were. And that, we believe, would eviscerate the constitutional venue protections. It would announce a new rule of law, and we don't think that this would be the appropriate case in which to do so. I would like to reserve the remainder of my 3 minutes.
We've got about 3 minutes left.
Thank you.
All right, Ms. Davenport, let me get you started here. Hold on just a minute. Okay, go ahead.
May it please the court, my name is Chris Davenport and I represent the state of Florida. Let me start with the venue issue. First of all, this was waived below, and I don't believe there's any question that you can waive venue below. They never challenged venue in Orange County. They filed a motion stating that they would prefer to be tried in Gadsden County, and they cited a statute when there's no proof of where the county is that the defendant gets to choose. In response, the state pointed out that when it's in more than one county, and there is proof of that, the state gets to choose, and that was the end of it. There was no challenge to venue below, so that claim has been waived. We've also argued in our brief that the challenge to statewide cross jurisdiction was waived below too. In the cases that we cite, the way that you challenge that jurisdiction is through a motion to dismiss. And even in Snyder, where it was a factual issue that this court decided, it was still done in a motion to dismiss pre-trial. We would submit that this is, equivalent to challenging the standing of someone to bring an action by waiting until after this 2-week trial is completed. We would submit that they did waive their right to challenge that.
Is jurisdictional in this context waivable?
We believe it is, Your Honor, because it's not really, it's kind of a jurisdiction, such an odd term for this.
What type of jurisdiction are we talking about here? We're talking about the jurisdiction of a statewide prosecutor.
Of the statewide prosecutor versus the court, yeah. And it's more, again, I would say it's more equivalent to a standing. Can the prosecutor file these charges? Sort of like, can a plaintiff file the complaint? It's not like this circuit court didn't have jurisdiction over these defendants. So we would submit that by failing to file a motion to dismiss challenging this pretrial, and he could have challenged it factually pretrial, like they did in Snyder, and they would either stipulated to the facts or addressed it somehow, it still needed to be challenged in a motion to dismiss. Just as a practical matter, if you're challenging the standing of someone to bring an action, you can't wait until the case is over and then bring it up for the first time. Even if they could bring it up at that point, we would submit that there is sufficient evidence in the record to support the jurisdiction of statewide prosecution, because all we have to show is that the violations of the criminal laws occurred in 2 or more circuits as part of a related transaction. There was testimony that the supplier of massive amounts of cocaine came down here to Orange County to buy that cocaine on 3 or 4 occasions, and he brought it back for the gang to sell. Granted, he's not listed as a conspirator, but he's essentially an unindicted co-conspirator. He was certainly their main dealer. He had a lot to do with this transaction, and we would submit that that is enough to allow statewide prosecution to bring this action. As far as the judgment, the conviction in the shooting into a vehicle, first of all, let me state that they did not object to hearsay below. They didn't raise this issue below, so we're talking about whether or not they can demonstrate fundamental error here. And it's our position it was not fundamentally erroneous. There was testimony about this.
That it is error?
Well, we did not argue that it was an error in our brief, but, you know, based on that statute, a plea of no contest can't come in. But I don't believe the plea came in. I believe it was just the judgment and sentence. Somehow the jury was told that it was a no contest plea. I'm sorry, I'm not sure exactly how that happened. But the jury was instructed about that it's not an admission of guilt, and everybody argued about that. But we would submit it's not fundamental error in light of that instruction.
I don't know that I heard a yes or no to my question.
You didn't
Was
hear
it
an
error
exact.
but simply not fundamental, or is it your position it was not error at all?
I certainly can argue that it was not error at all for this judgment and sentence to come in the absence of an objection especially. But the plea, there's certainly an argument to be made that the plea itself is what that 90.410 is addressing.
If the judgment had not come in, would there have been sufficient evidence in the record for the conviction on that count?
Yes, there would have.
What evidence was there that these parties were guilty of firing from a vehicle? Wasn't that what the charge was?
Yes, and there were several witnesses who testified about the gunshots being fired as they got out of the vehicle. As far as the whole question was whether or not they were in the vehicle, let me point to page 814 in the transcript. This woman testified, she saw the car drive by, and she said, what did they do at that time was the question. She said, well, before they got out of the car, other shots was fired. I don't know where they came from.
Would that have been enough then to get to a jury
I would
on
submit
whether
that
they
that's enough
shot
to
from
get
the
to the
car?
jury, yes. Finally, let me add that we don't have to have this predicate conviction. We do have 2 or more on both defendants with other predicate acts. So again, we have a harmless error argument here. As far as DALTONICA,
well, would that necessarily be harmless, or would it need to be retried because we don't know whether the jury found more than these 2?
Well, you have to consider the overall evidence at trial and how much, I would, first of all, let me say again, this is enough to show he was shooting inside the car. So even taking away the fact that they admitted their guilt of that, we do have a witness who indicates that the shots started before they got out, although, again, other witnesses said they were out of the car. There were a lot of shots fired that night. Certainly some of them took place out of the car. This woman says that the shots started while they were still in the car, which is sufficient. Even throwing out this predicate act, we have enough to convict these guys, and this was just one small
What 2
predicate.
acts did you have proven against DALTONICA if this one was thrown out?
We have the threatening of the witness. After he got in a fight with his brother, we're going to kill you. And we have the conspiracy to traffic in cannabis, which was supported by the testimony of Mr. Smith, who said that Terrence told him that DALTONICA ran the trap house and they supplied 50 pounds of marijuana. So we'd submit that there is sufficient evidence to support DALTONICA's conviction as well. If the court has no other questions, we would ask you to affirm. Thank you.
Okay, thank you. 2 minutes and 56 seconds.
I'll try to be brief. Let me address the jurisdiction issue first. The case law is clearly quite clear that, and I quote from your decision in Brown, if the office of the statewide prosecutor files an information but lacks jurisdiction to prosecute a case, then the trial court's jurisdiction is not properly invoked. That follows the Zanger decision in the 4th DCA, two different decisions in the 1st DCA, Winter 1 and 2, and also the Lugar case in the 4th DCA just 2
What about
years ago.
her contention that there was other evidence other than the conviction to indicate that some of the shots emanated from the car? What about that?
I literally begged the court to read the record. The statement that was just made, that witness testified that they discharged their weapons as they got out of the vehicle, is not in the record. And what is clear in the record is that the shots that were fired before they got out of the vehicle were not fired by them. And that's quite clear from both that witness and the other two witnesses. They got shot at by the people in the woods. Then they got out of their car. Then they fired back, some of them. The idea that there are two other predicates on DALTONICA is absolutely untrue. The threat, yes. The marijuana conspiracy that she just referred to was null prost. It didn't even go to the jury because there was no connection to Orange County for it, nor was there any evidence regarding DALTONICA on the marijuana conspiracy. It is true that Mr. Smith said that Terrence once said that DALTONICA ran a trap house where they sold small quantities of cocaine, not marijuana. I represent to the court, as an officer of the court, that I am unaware of any evidence in any part of this record that suggests that DALTONICA Shorter had anything to do with the sale of marijuana. Nor is there any evidence that he had anything to do with any other predicate incident in this case. It relies entirely on, there was the conspiracy to distribute cocaine that he was charged with, which the jury acquitted him of. So a relial on that would be a direct, inconsistent verdict. It is the case that his guilt in terms of two predicate acts hangs entirely on the utterly inadmissible document. And the correctness of the admissibility of that, I guess, is now being argued for the first time at oral argument, because I can tell you in the state's brief, they didn't make any such argument that that was not error, nor really could they. So I think those are the main points that I wanted to hit in rebuttal. I urge the court to look at the case law on jurisdiction of the Office of Statewide Prosecution, because if the court were to affirm this prosecution, I believe it would be breaking new ground. I really do believe it would conflict with the case law in the other cases. The idea that this jurisdiction can somehow be waived. I mean, in Brown, there wasn't any evidence that the defendant objected to jurisdiction at trial or on appeal, or on his first 3850. Brown, where you guys sent it back.
Brown has, I understand, has holding that it's the jurisdiction of the court to hear the case.
And raisable for the first time on a successive 3850 for the first time, because jurisdiction can be raised at any time. We raise it now, Your Honor. Thank you.
Okay. Thank you both very much.